Oh my God, I would say that.
All right.
All right, well, welcome back to our afternoon session. We have reconstituted the panel. And we have Judge Nardella joining us on my left from Orange County. And Judge Stargell is back here on my right from Lakeland. We have two cases set for this afternoon. Ready to proceed? Go ahead.
Sorry. No, sorry. May I please report?
Yes.
Counsel. Melissa Giassi, I represent the appellant. I would please reserve 5 minutes for rebuttal.
Got it.
I'm going to start with the argument that there should have been a directed verdict granted in the case in chief. Respectfully to my opponent, his client has missed the mark in this case from the very beginning. They concede repeatedly that there was covered damage under the claim, but instead of deciding to issue partial coverage, they denied the claim entirely. And that's not how it should have played out. You don't get to try a case piecemeal. You either deny it, or you cover part of it and then people move forward accordingly. So,
Counsel, may I ask a clarifying question? I understand the damage you're speaking of, and correct me if I'm wrong, is the tree that was down when they returned and damaged the lanai. Is that correct?
it's not.
Was there ever a claim made for either of those two items that were damaged?
I think arguably the recorded statement where the corporate representative concedes that it was mentioned, and I don't understand why that can't constitute a supplemental claim. The fact that the carrier went ahead and denied the claim without investigating that, without, there's some testimony during trial about how the insured never provided photographs or documentation. Well, they didn't adjust the claim. They never asked for those.
But
So
when you brought a lawsuit, right? You filed a complaint, correct?
Correct.
Were those two items of damage ever listed in the complaint or otherwise specified as the basis for you guys moving forward?
the complaint is pled very broadly. So, respectfully, I think it covers all loss in the policy. I think I've quoted here somewhere. So, I mean, the complaint was certainly not limited to the roof. I mean, the assignment of benefits in this case unequivocally assigned all benefits for this hurricane claim.
Okay, well, let's go down that rabbit hole. Okay, so the lanai was fixed by the insured, correct?
Correct.
What was the damage that he was seeking for fixing the lanai?
I understand the angle for the questions, but I don't think that that's necessarily, we can't look at a claim in a vacuum. Claims are treated as a total in totality all the time. You can see that when courts are having to address issues of appraisal under partial coverage. The way this should have played out is we're going to cover the lanai, not the fence or not the, gating. We're going to cover the tree debris removal based on the coverage for the lanai. But the value of that is X, you're under deductible. So, you're not going to get any money. And then had their, when the S&E came in and filed suit on the roof claim, then I do agree that I would not have this argument. But at the end of the day, they chose to deny the claim. They chose to be advised repeatedly by the insured that there was damage caused during the policy period.
Well, the insured has posed this question in their initial brief, and so I'm going to pose it to you. And then what they say is that you point to no case law or other authority which has found that a company with an assignment of benefits can meet its initial burden at trial by pointing to damage unrelated to the scope of its performed or contracted services.
So, and I understand that argument, but the cases that are cited in support of that are utterly distinguishable. So I will flip that and say that the appellee has not cited a single case that says simply because it's an assignor bringing a lawsuit or an assignee bringing a lawsuit that changes the burden of proof. So what is happening in the two cases dealing with the assignment of benefits is solely limited to the standing and whether or not, that's the analysis that the Brown case goes into. That's the analysis that the other cases go into. So there's no case that says there's a different burden of proof when it's an assignee bringing the claim. I mean, they could have denied the claim, issued a letter saying it was under deductible and we might not be here, but they chose to deny the claim. They chose to not ask questions about that. They repeatedly conceded during their testimony, the corporate representative specifically, that they were told about this. At no point did they ask for, photographs. I mean, I think she testified, the corporate representative testified generally at trial that no photographs or documentation were provided, but they were never requested. So there's no obligation for an insured to, just voluntarily turn over things like that. So, it's a unique set of facts, and I realize that, but, this has been litigated throughout the case. There was a prior motion for partial summary judgment on the fact that there was loss during the policy period. There could have been coverage exclusion defenses raised just as to the tree or the lanai. Maybe there were post-loss conditions, maybe they didn't, retain documents, maybe they didn't have photographs if those were ever requested, but, I just don't see how the fact that it's an assignee bringing this lawsuit, that changes the burden of proof.
How does it not change the scope of what the assignee can enforce though?
Well, because the assignee is assigned to the entire claim, and I mean, the language of the assignment of benefit is unequivocal. I mean, paragraph 2, any and all insurance rights, benefits, proceeds, causes of action. I mean, we could go about this in 2 ways. There could have,
Related to the provision of services though, right?
I'm sorry.
Related to the provision of services?
Well, it doesn't necessarily qualify. It says as agreed upon by the insurer and SFR services as documented in the final agreed upon insurance estimate. So, they came into this case after.
You don't think that limits it to what the services, the services that are being provided?
I think that under a standing analysis, which was not a defense raised in this case, maybe there could have been a carve out for the insured to maybe file suit based on the lanai, based on the debris removal. But the fact of the matter is, even when confronted with the additional coverages, the only response from the corporate representative was, well, this was a denied claim. So that wasn't triggered, despite the fact that there was unequivocal, everyone conceded that there was damage to the
Lanai.
thank you.
Yes.
I don't have one of those around my pool. I live in an old house. So, I candidly, I think the burden of proof is clear. This wasn't even a case where we were dealing with an exception to an exclusion. There was no interior damage claim. So, under an all risk policy, once there's a loss established under, during the policy period, and there was unrebutted evidence that, the insured came home, he saw the damage, he testified that he fixed it. There wasn't even, any questions asked by the carrier during trial. Well, how much did you spend? Do you know? I mean, but, the jury did hear, $500. I think that when you look at the arguments made compared to the jury instructions that were given, I mean, the judge, told them to follow the law that, at trial, Florida Pencil wanted different jury instructions. The judge sided with the jury instructions proposed by the insured. There was no cross appeal, anything like that. And it just says the plaintiff proved by the greater weight of the evidence that the property suffered a loss or damage within the policy's effective data coverage. So how can they answer that no? They can't. There's no evidence that lanai wasn't damaged. There was no evidence that the tree wasn't, didn't fall down and was removed, triggering the additional coverages based on the coverage that automatically flows from the bent lanai. There's just, this is being framed as almost like a gotcha attempt on our part. Well, I fully disagree. You look at the short timeline between the reporting of the claim, you look at the fact that despite being told, I believe the testimony was from the corporate representative, that when the claim was reported, Ms. Corbin called in and reported damage to her home and her roof. It wasn't just limited to that. The assignment's not limited to that. The pleadings aren't limited to that. It covers the entire loss. So, and this, again, this was not some sort of argument that, came up at trial. this was litigated all along between the parties. So looking at the question that, in my opinion, the judge properly instructed the jury on as a matter of law, because that is the burden of proof on an all risk policy. And again, I'll walk you through it. I've been involved in trials before. There's damage. Let's say they got to the second question and said that there was no exclusion, but let's just say, they didn't think the roof was covered. They characterize it as a battle of the experts. Well, they can award $400, and guess what happens then? There's an $8,500 hurricane deductible judgment in favor of the defendant. That's how this should have played out. There's nothing that says the burden of proof on an assignee is different under an all risk policy. Did I answer the question?
Yes.
Okay. Go back to it. And I just want to emphasize that, you don't try a claim piecemeal. If this was, if this was teed up early on in the case, if they wanted to move for partial summary judgment on the fact, that the assignment was somehow limited or somehow changed the burden of proof, I just don't see that. The only cases cited in the answer brief, the Brown case and then the Nikon and one of the other second DCA cases, they're analyzing standing, and that's when they tell you to look at the totality of it and what was carved out and what was the intent of the parties when they actually, executed that assignment. But it doesn't touch on the standard of proof. There's just nothing that changes that. So, they had an opportunity to raise coverage defenses as to, there's other damages. If they felt like, the wind damage, they took a recorded statement from the insured, never been provided. She conceived, time and time again that they were made aware of these additional damages. And, I think the unrebutted testimony is that they came home the day or two after Irma. They saw the vent, one eye, they saw the tree, we fixed it. They had the tree removed, and, then they filed the claim. So I don't understand how the burden of proof changes under this scenario. The burden does not fall on the insured to adjust the claim. So once the carrier is put on notice of these damages, they have to fully investigate. They make a big deal that, they weren't provided with pictures. They didn't ask for pictures. This was a very, 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 hurriedly decided claim. So, and even I'd like to point out, the engineering report that was relied on to deny the claim specifically mentions the pool enclosure. So, they were on notice of this from the very beginning, call all of that. And so they kind of extend this and they try to make my argument seem illogical by saying under SFR's logic, if it proved there was washing machine damage, a washing machine leak at some point during the policy period, it would have met its burden of entitlement to an all risk policy. No, unless it was caused by Irma. The assignment of benefits was every single cause.
Well, that is kind of the end of your argument, right? That anything that could happen to the house during Irma, even though you have an assignment of benefits for a specific set of services, that anything that happened,
I understand the
an
court,
assignee would be able to
Sure.
pursue.
and I understand the court is focusing on the services, and I think that doesn't impact the burden of proof. The services affects the standing of, possibly if the insured wanted to file a separate claim. That's the way those cases are teed up. I signed this, this service company, they perform the work. That's not the facts that we have here. It's unequivocal, every single, assignment, there wasn't any evidence that came out that, SFR did not intend to reimburse the insured for the monies that they spent. There's all sorts of ways they could have gone about this. So, And I just, I just want to reiterate, when you start to finish, you look at the complaint, it's broadly pled. It says all damages of the hurricane. There's a statement of facts in the record. It frames the issue as SFR filed a lawsuit alleging that Florida Peninsula breached the subject policy because it failed to afford coverage to the loss and failed to pay all assigned insurance proceeds due. You look at the paragraph dealing with the insurance proceeds, and that says all insurance proceeds, all causes of action, all of that. So I understand that, there are those 2 or 3 cases mentioned in the answer brief that deal with standing and, in some cases, they look behind the intent of the parties, but that doesn't say to me that there's a different burden of proof, and those cases certainly do not say that.
You have about 5 minutes remaining if you want to
Okay,
reserve that for your rebuttal.
I'll reserve for rebuttal.
Good afternoon, Your Honors. May it please the court. Samuel Spinner with Conroy Simberg on behalf of the appellee, in this case, Florida Peninsula Insurance Company. We respectfully request that this court affirm the final judgment and the order denying appellant's motion for new trial and judgment notwithstanding the verdict, because appellant has not shown that the trial court committed any reversible error in its evidentiary rulings, nor that the verdict is contrary to the weight of the evidence in this case. And therefore, the jury's verdict for Florida Peninsula and the final judgment must stand. We don't dispute that the general law in this state is that when insured sues an insurer for all risk policy benefits, they generally just have to show that there was a loss or damage to the property during the effective dates of coverage. But as the court's already recognized in questioning my colleague, this case was not brought by insured. This case was brought by an assignee whose claim is necessarily limited to the scope of what was assigned to it. And in this case, all of the testimony shows that the only claim that was assigned to SFR was to replace the property's roof. SFR did not receive any other potential claims with its assignment. It only estimated the cost of the roof. Mr. McGraw testified he was only going to replace the roof and that they weren't doing any other services at this property. And as you noted, Madam Chief Judge, the AOB itself talks about you're gonna have to pay us what the final estimate for our services is, and the final estimate didn't include anything other than a roof replacement. And so since their AOB was limited to the roof, they necessarily had to present evidence that the roof was damaged during the trial. And on that issue, it's clear that we had a battle of the experts. We had one engineer saying that the roof was damaged during the policy period, and our engineer saying that there was not. And so there was clear support for the jury's finding and rejecting their engineer and determining that there was no loss to the property during the policy period. We have to look at AOB cases in the scope of the services that are assigned. I brought up the washing machine leak in our brief because that's exactly the argument that they're making. All we have to show is a loss to the property during the policy period. That's what the first question of the verdict form said, and that's what counsel argued at trial. They never said we're actually going to perform services or reimburse the insured. They said technically all we have to show is a loss and therefore we win. And so under their logic, any loss to the property at all during the policy period would have triggered their rights to all risk insurance policy benefits when they're a roofing company who's only working on the roof.
What is your response to the argument? This is really a standing defense and everything was very broadly pled. It was the language in the jury verdict was very broad. And so if this was an issue that you wanted to raise, it should have been raised as some sort of affirmative defense or in summary judgment.
Well, to answer your question, Madam Chief Judge, we did raise this at trial. We moved for directed verdict on this issue twice. We argued it in connection with the jury instructions. And because this was a surprise, this wasn't something that was litigated. This was an issue that they came up with at trial as a way to say, well, we have an issue about the roof because of the battle of experts, but aha, he said the pool was damaged. We're not doing anything with that. but we're going to use that as our way to get past that first question and into defenses, even though they admit they didn't do any services for it, they weren't doing it, and counsel today said that those damages would have been under the deductible anyway. So what could possibly be the harmful error in this case if the jury's already decided that the roof was not damaged, which is clear from their verdict, and then we've got an admission that the remaining damages would have resulted in a judgment for Florida Peninsula anyway. So I think that's only further underscored the fact that there was no harmful error committed in this case. None of the experts were asked about these other issues. This was something that came out through Johnson's testimony, and he never presented any evidence of what these repairs cost or what he specifically did. All he said is a couple screens came out, I popped them back in, and the claim wasn't reported until over a year after that. So, or 11 months after that. And so it's not like this is a case where Johnson reported the claim right after the storm and said, hey, I just had all these things happen to my lanai. Can you go check my roof and see if there's damage? He chose not to report that claim. The only claim that was reported was when he had already gotten SFR involved and they told him you've got roof damage. And then he called, and that was the claim that was reported. And that was the claim that was assigned to SFR. And so I think it's important that there has to be a difference in the burden of proof in an assignment of benefits case, because we have to look at what they were actually assigned. And I think the same would have been true in had this been an insured case and they brought up some completely unrelated loss at trial that wasn't within the scope of what they had pled or argued or presented evidence about. I think the jury clearly understood that this was a roof case. That's what the experts were asked about with the causation analysis. That's what the parties argued about in their opening and closing primarily. This was a case about, did the roof sustain damage due to Hurricane Irma or during the policy period? And the jury reviewed that and determined that it did not.
And I can't recall in the closing, the request for damages. Was it contained only to money relating to roof repairs?
Yes, Madam Chief Judge. Throughout this case, they asked for the dollar for dollar of their estimate to replace the roof. And that's, again, all that they ever presented evidence of damages for. Neither of their experts were asked, hey, what would it cost to replace these screens or to fix the vent enclosure or to remove trees from the property? Those were never presented to the jury. This was, as counsel said, it was a gotcha tactic used at trial to try to say, well, we're going to have an issue proving our case on the roof. So we're going to lean onto this other claim that Johnson never personally made, even though he could have, and use that as a way to get to the coverage defenses for a claim that's not being brought before the jury. And I think it would have resulted in even more confusion in this case. And frankly, we tried to clean this up. We brought this in on 2 motions for directed verdict. We argued it during the jury instructions. And at one point, the judge even commented, you know, it doesn't seem like SFR even tried this issue of the pool enclosure, but ultimately punted on that and allowed it to go forward with the question as it was. And so I don't think it's fair to fault my client when we tried our very best to clean this up, to raise these arguments, and to have the judge appreciate that they couldn't present evidence of a claim that wasn't actually assigned to them. And there's clear support for the jury's verdict in this case. And I would note that every independent person who's reviewed the evidence in this case reached the same conclusion, because it's important to recall that we had an arbitration in this case, and the arbitrator reached the same verdict. He said SFR did not prove their loss during the policy period. Then we go to a trial and we get another unanimous verdict with the same exact finding. And so I think when you look at that every person who's ever reviewed this case who was independent, they've all reached the same conclusion that in this roof case, which is what was argued before them, SFR did not meet its burden to prove that the roof was damaged during the policy period. That was clearly what the jury understood to be the case, which we can see from their verdict. And a JNOV would require no evidence to support the opposing party's position. They quibble a bit with our expert's testimony, but it's pretty clear that Mr. Lehman testified that all of the damage was unrelated to Irma and pre-existing, and therefore it didn't fall within the policy's effective dates of coverage. So I think what we would ask for in this case, if there's going to be any elaboration on it, is that there has to be a limitation on an assignee to recover what they've actually been assigned by the insured. And while the cases that we cited are really issues of standing, it's essentially the same argument that What you assign goes to the assignee, and what you retain, you can sue for. And in this case, Johnson chose not to pursue a separate claim. He didn't present any evidence of damages. He didn't do anything other than fix this himself, wait a year, and then sign an AOB that every witness in this case testified was limited to the property's roof. We didn't really get into any of the other issues, but I'm just going to briefly touch on them. It's clear that our expert, Mr. Giza, was qualified to testify as a pricing expert in this case. They've argued for a Dauber challenge, but it's still unclear why he would not be qualified. He owns a roofing company. He's done these roof replacements before. And any issue with admitting his testimony was harmless because it was the damages, and the jury didn't reach the issue of damages. As far as the field adjuster's photographs, those are redacted in every first party case. It's just how field adjusters generally prepare their reports. As they have photos, they put notes next to them and they're redacted. They didn't seek those unredacted notes before trial. They never have argued that they were not privileged. They argued that we put them at issue, but we never did because we redacted everything. The field adjuster did not have the unredacted notes during his testimony. And it's not like we put in some of them or redacted some of the notes to make it more favorable. We redacted every note because they were clearly work product based on the field adjuster's mental impressions during the inspection. And lastly, Your Honors, with the closing argument, the trial court did not abuse its discretion because our policy clearly says that the loss must be sudden and accidental. What SFR did is they cited a case for the trial court that involved a different carrier's policy that required only a direct physical loss. And based on that, they said the law in this state is that the loss just has to be direct, but that was just the law applied to that policy. And in our policy, that language is clear. It has to be sudden and accidental. And in fact, SFR's counsel during their opening said sudden and accidental and didn't object when we said that during our opening. And so in closing, unless Your Honors have any further questions, SFR has not shown any basis to have a new trial in this case. We fought an uphill battle, as Your Honors saw from the transcript. SFR convinced the judge to instruct the jury based on a different carrier's policy. It allowed them to switch their corporate rep to a different witness who then became the pricing expert at trial. They allowed the engineer to testify about the inspection he did during the trial and then come in and say what he saw the day before. And despite all of that, I think the jury cut through the noise. They recognized that this was a roof case. They said, we agree with the defense that the roof was not damaged during the policy period, and they entered a judgment or a verdict for Florida Peninsula that's clearly supported by the evidence. And so for these reasons, this court should not disturb the jury's verdict, and it should affirm the final judgment for Florida Peninsula in all respects.
Thank you.
Thank you.
Right under 5 minutes remaining.
Thank you. I just want to tell you about it. So it's page 1437 of the supplemental record. This is the corporate representative testifying. We received the reporting of the claim. I believe that Ms. Corbin Johnson reported the loss, that there were damages to her home, to the roof, to hurricane. So, from the beginning, this claim was reported. They conceded during the recorded statement that it mentioned these other damages. I don't know why they didn't decide to inspect. I don't know why they just, went, were notified of that. I don't understand that, but, what counsel is trying to argue, to just wiggle out of the fact that the jury verdict as phrased, as contested and could have been cross-appealed if that's her position, that there should have been sudden and accidental language in the instructions and in the jury verdict. They didn't file a cross-appeal on that. I don't think that I think it's pure speculation that the jury knew it was about the roof. I mean, I think that there was certainly argument presented to the jury. There was evidence that there was other damage. There was, extensive cross-examination on the fact that the debris removal would have been recovered had it been a covered claim. That there was just, and I understand that, but we're just dealing with a breach of contract case. I don't think that there's any authority for the fact that, if there's a valid contract and if there's a breach, namely for not paying for these two covered claims, that there has to be specific damages on that. There wasn't an interrogatory jury form. They didn't ask for.
Damages isn't part of a breach of contract claim.
I'm sorry.
Damages is not part of a breach of.
No,
contract.
but what I'm saying is the argument they're advancing is, well, there wasn't specific damages on, those amounts, but there were damages from the purported breach.
Well, why couldn't the jury have taken all of that, knowing that it's a breach of contract claim, knowing that they're dealing with an assignment of benefits,
Mhm.
knowing that there's roof damage being discussed,
Mhm.
and decided that when they read this question on whether or not there's a loss, that it's all within the context of a valid breach of contract claim, which is limited to what the assignment is for.
Because I think that that's contrary to the jury instructions that the court provided and told them to follow the law, and I think it's contrary to the question that they answered. So, at a very minimum, if the court doesn't think that, a directed verdict was improper, I mean, I would submit that the evidence or the jury's verdict was against the manifest weight of the evidence. And, certainly warrants a new trial, if nothing else. So, I don't know if the court has any other questions. I do think that, and this is, this is something that, permeated the case to some extent. There was a lot of back and forth. Again, I just want to point out that the jury instructions were challenged and not cross appealed. So they're stuck with what the question was. And as answered, the jury, there's no evidence to support that verdict. Or in the alternative, it's just so far off that it warrants a new trial on that specific issue. So, I'll just kind of stand by the evidentiary arguments raised in the brief as to the Dauber challenges. I do think that there were several times that at least Mr. Hughes crossed the line into, testifying as an opinion testimony, same with the corporate representative. And, the scope of the assignment is for all benefits. So I just don't, I understand it in the standing context, but I just would reiterate over and over again that has no impact on the burden of proof. And I realize I'm almost out of time, but I'll add just a few things. The claim acknowledged for two of the record, they just describe it as when Hurricane Irma. The denial letter that encloses the expert report at 421 does note that specifically that the insured told him about the swimming pool enclosure. And then just looking at the broad allegations of the complaint, the policy provides coverage for all losses and damages and expenses. So we're asking for the court to reverse the final judgment and remand for the entry of at least directed verdict on the first question, which was there was no reasonable evidence that the jury could base that response on, that there was no loss during the policy period. And then have a new trial on the defendant's exclusions and damages to the extent the court thinks that I don't quite get to the directed verdict standard. I certainly think that the verdict against the manifest weight of the evidence, and it would not be an abuse of discretion to reverse and remand for it. Thank you.
Thank you very much. All right, thank you. We will hear our second case now. It's 2336 in SFR Services versus Tower Hill. No, it's fine. Take your time.
Melissa Jassy again on behalf of the appellant, SFR Services, and I would again like to reserve 5 minutes for rebuttal.
Okay.
Fraud and concealment clause is the new EUO form proof of loss. It's popping up everywhere. It became a huge problem prior to the 4th District's opinion and TRIP, which outlined the distinction between misrepresentation on application. The third district has adopted the same rationale, so has the fifth. And, you know, I just want to reiterate that a line has to be drawn somewhere, and I think the line has to be drawn in this case. There's just was not enough evidence to submit this question to the jury. That combined with all of the other inflammatory, irrelevant, inadmissible evidence, you know, if at a minimum, just, you know, should warrant a new trial. So, as pled, and, you know, parties should be held to their pleadings. Says says Tower Hill is aware that plaintiff utilizes subcontractors to perform repairs, which subcontractors charge amounts far below the amounts contained in plaintiff's estimate. So there was no evidence of trial about that, no speculation, you know, there was speculation. But they didn't prove that.
You're
And-
saying there was no evidence presented on, say, the repairs?
There was no
That-
repairs done. I mean, there was, I believe, some
Temporary
repairs.
repairs where
Right.
they marked it up double on two of them and more than double on another one?
I think that there was evidence about that, but that's not the misrepresentation that was pled in the affirmative defense, so specifically. This again was another very, very quick, you know, decision on the part of the carrier. The agent of the insured called Tower Hill. They had an engineering company inspect. Less than 3 weeks later, it was denied. There was an assignment of benefits assigned in 2019. And then there was an estimate submitted to Tower Hill in April of 2019. And then later, my client filed the lawsuit. So.
That estimate that was provided
mhm,
used Exactiment,
yes, sir.
correct?
Mhm.
And when it used Exactiment, what was the price per square that it came down to? Do you recall that?
I believe that, my opponent, who's much better at math than me, apparently has that in a footnote somewhere. I want to say 3,000. Does that sound right?
Yeah, that's what I recall, is in the 3,000, and then they came back at 142,000 or 143,000, something
Yeah,
like
there's
that.
certainly some room for negotiation.
Well,
Yeah,
and that's exactly my question. So that you say there's room for negotiation. So when a claim's being made and you're saying this is what the loss is, when up front they say 190,000 based on this price, then they drop 50,000. You have other people saying it's in here, you know, the 80,000 down there. Where's the room for negotiation if you're looking at what the loss is?
so there's a couple of angles that I think are important to know. Obviously, the Florida Supreme Court has defined the actual cash value. There have been no repairs made. Now, there are some definitions in this policy that, in the Florida endorsement, that's a 438, where Tower Hill defines actual cash value as the cost to repair or replace the covered property. So, you know, this is their defense. The onus is in their court. You know, there was no unequivocal evidence as to the cost to repair or replace the property. You know, they could have done discovery, brought in the contractor, figured out if a contractor had been retained to do this work. Even if SFR had not paid the subcontractor, I believe that a binding contract would suffice under Florida law, because, you know, a cost incurred does not necessarily mean you have to pay the cost. It's just that you're obligated. So, you know, there are just many ways that this case could have been proven, and it just wasn't. And that, combined with the inflammatory and irrelevant and improper impeachment evidence of the Knox agreement, which was essentially a business divorce between my client and his former partner, and the focus on the carve out of the $1,200 per square foot, ignoring the other, I think, $4 million, you know, lump sum payout, combined with the fact that, you know, this property wasn't even part of that. So, you know, to the extent that that was, you know, permeated through the trial.
Didn't that come in though? When Mr. McGraw testified regarding the highest rating? Wasn't it used for impeachment?
Well, I think that it was used for impeachment, but, was it? I mean,
Wouldn't that be a question of fact for the jury?
but it was used for impeachment. It's not necessarily, I think the way we argued it in the brief was, it wasn't a central, issue. It wasn't directly contradictory to anything he was saying. And not only that, but it was used part and parcel to the other, lump sum $1 million payment that, putting aside the fact that it's, completely irrelevant and highly prejudicial to, mention this without giving the jury the big picture, that there was also a lump sum payment that it had nothing to do with this case. So I just,
Counsel, can you expand on why it's highly prejudicial?
well, it's highly prejudicial because it had nothing, it has no relevance. So I don't understand how it has any probative value. All it could do is, prejudice the jury against my client. And, that was the theme. $1,200 a month or $1,200 a square foot, that's what he pays. Well, leaving out the fact that, that there was also a lump sum payment, that this was a,
So it's a
dissolution of a
confusion
partnership.
issue, is that?
The confusion, it came in through the corporate representative who was allowed to testify about this, just based on pure, inadmissible, hearsay from a prior deposition and a prior case. All of that, it was a theme that was hit on repeatedly.
Are you aware of any cases that limit impeachment evidence? And I understand your argument that it was improper impeachment. But if we disagreed with you on that, are you aware of any cases that limit impeachment evidence by the unfairly prejudicial, through an unfairly prejudicial analysis?
I think that argument was more directed towards the introduction of it in general. So I think maybe that was more the focus of the motion than limit.
Okay.
So I think that I understand that.
Yeah, I think you answered my question. Thank you.
So, this policy had a different definition for actual costs. And, than the common law definition, which is fair market value under Trinidad. But, when you just look at how this case was pled, you look at the evidence that was presented, and then I think, maybe getting to some of the cases that were relied on, to essentially attempt to convince this court that there was some sort of misrepresentation might make a difference. So, there's a line of cases cited in the first argument section and the answer brief. I'm kind of starting on page 16. And there's just not a lot of cases, this is a new concept, I think for years, and I was involved in a lot of it, any misstatement. There's a recent opinion from the Fifth where something to do with a home inspection report, was used to forfeit coverage, and there was even a concurring opinion saying that he didn't think there was even evidence of a false statement. And I think that's kind of where you have to start with here, like, where's the false statement? And then, there's, they pled it as SFR uses contractors, and that's not their true cost. The estimate doesn't represent the true cost, but where were the contractors that testified? Where were the efforts to bring that evidence, other than just through pure, inadmissible hearsay through the corporate representative, through, the scope expert that certainly went a little bit outside what he was supposed to do. He was supposed to testify as to, what he would.
There was plenty of testimony that they used subcontractors, that was kind of their MO in their business.
Right, but,
They go out and use subcontractors, and there were markups. So the question is, was there a concealment that they were doing additional markups, or was that somehow fraudulent?
well,
Why isn't that a question of fact to the jury when there's over $100,000 difference between some of them, and they had dropped their offer 50,000?
I disagree that, there was specific contractors that came in on this claim and said, we've agreed to do it for this work. So,
So you don't think that the jury could have taken the, this is what exactament does, this is what, it could have been we said 3,000 square foot, it could have been 1,200 square foot. Could have been $1,800 a square foot. That evidence alone wasn't enough for the jury to conclude, as the amended or as the affirmative defense says, that there was misrepresentations as to purported value of repairs.
Candidly, I don't. I mean, where was the evidence that the cost to SFR was less? I mean, there was not a witness that said that. And that's what they pled. They failed to prove it. The testimony at trial just, reiterates that it was just too high. That doesn't meet the burden of what they alleged in their affirmative defense. And then, we have to get to intent. I don't see that there was ever evidence of any intent, presented at trial. And then, let's not ignore materiality. This claim was reviewed and denied quickly. And I understand that, there is some exceptions to that. And I kind of wanted to distinguish, the case.
I had a question on just the intent, because I think the initial brief makes the issue that if there or raises it in a way that if there was a misrepresentation, there was an intentional misrepresentation. Is that kind of the argument?
That's what the law said, yes.
Okay. Was that preserved? Because when I was looking at the directed verdict, I see, the basis for the argument that there wasn't reliance and this is materiality, and the motion discusses the elements of a material misrepresentation and just cites the element that has to be known, but never argues that that was lacking here, to my view. So was it preserved, and if so, where?
Well, it was preserved in the post-judgment motion because there was an intervening change of the law. And there for that trip was.
Where in the post-judgment motion?
I can give you the.
Yes, and I'll find the site. I
Yeah,
have
it was certainly
I have
discussed.
2391 as
Yeah,
the
yeah.
renewed directed verdict
And-
as the
and-
record site, but
And I
but
just,
to my view, Triff was focusing on that materiality and reliance more so than this kind of separate argument that has to be specific evidence of intent.
well. The facts were different, that's true. I mean, prior to submitting this one proof of loss.
Right, and I'm just
The
asking about
insured-
preservation.
Yeah,
I'll-
yeah.
I'll go back and check.
Yeah, the insured had those estimate, he had a $20,000 and $30,000 estimate in his pocket. And just briefly, I realize I'm getting close. Some of the cases that cite, first of all, Alvarez is one of the cases that is relied on in the brief. And in that specific instance, I believe the jury was instructed that inflating a verdict or inflating an estimate, overestimating the value and mistake or inadvertent is not sufficient to avoid the policy. Again, like I said, in Triff, before this one proof of loss was prepared and submitted to the carrier, the insured was had in his possession two estimates, a quarter to a fifth of the estimate that he put on this one proof of loss. And then, some of the other cases that deal with, I understand, the case was denied. And there's some case law cited, and it's 24 of the brief. All of those just contain so much more evidence of intent, materiality. I think the Elhad case, there was evidence of the subcontract, which we don't have here. There was evidence of an agreement between Elhad and Hunter that included extra room for a $500,000 loan to Elhad and $700,000 for attorney's fees. I mean, that kind of evidence, I wouldn't be standing here in front of you today. The Michigan Miller's case that they rely on, the evidence at trial had the proof of loss value and the total damages to be in excess of $90,000. And that dealt with the fire and the arson and all of that. So, this has been used to forfeit coverage for so many insureds across the state. And we cited the case law that says an inflated estimate is not enough. So I do think there needs to be a line. I don't think that anytime there's a disagreement over price and scope, every single trial, when there's a covered claim, there's a disagreement between price and scope. You know, here it is. They start off, they say it's excluded. And then in the middle of the snowball of this type of defense that picks up speed, you know, they bring it in, they say it's overinflated. And candidly, I just don't think that they proved the allegations of their case. One other thing that I'll address and then I'll sit down. We, both my opponent and I mentioned the web roofing case. And I think I'm accused of, if you interpret the plain language of the concealment and fraud provision, it would cause chaos. I think we can distinguish that. Oh, SFR status as an assignee does not allow it to carte blanche misrepresent the cost of repairs to the insurers of the state. Okay, so web roofing dealt with an alternative dispute provision. If that had not been extended, when there's an assignee, there's nothing left. Here, unclean hands, common law fraud, you know, just because there might not be contractual fraud, you know, they're not left without a remedy if someone gets up here, you know, makes a claim and blatantly lies. So I'll reserve the rest of my time.
Okay,
Thank you.
thank you.
Good afternoon, may it please the court. My name is Ryan Jones and I represent Tower Hill. The briefs in this case addressed a number of different issues, but the appeal actually comes down to just one question. And that question is, should the jury have been allowed to consider the misrepresentation defense? And the answer is that it absolutely should have, yes. The issue that comes about is that the entire misrepresentation defense is based on SFR's estimate. The estimate represented that the cost to repair the roof would be $190,000. And from that amount, SFR would take about $15,000 in profit. On the stand, SFR's corporate representative testified that is not the real cost to replace the roof, and that is not the real amount of profit. The evidence that came in after that showed just how far off that estimate was. The testimony that counsel talked about earlier with the Knox agreement, that shows that SFR had an agreement with at least one of its subcontractors to repair roofs for $1,200 a square. If we add that out, that would be the cost of about $75,000 to replace this roof. Another witness testified, Mr. Rakos, who just so happens to be a subcontractor of SFR, testified that his company repairs roofs for between $950 and $1,150 a square. Extracting that out, that's just under $60,000 to just over $71,000 for the entire replacement of the roof. And then Tower Hill's corporate representative testified that on average, Tower Hill pays $1,126 to replace a tile roof. Extracting that out, we have $70,000 for replacing the roof.
What is your response? There's no specific estimate as to the homeowners, what it would cost to replace a roof with a homeowner here. And for that reason alone, it shouldn't have gone to the jury.
There was no specific, the only reason there was no specific actual cost here is because SFR took the position they hadn't retained a subcontractor to do the job yet. So the only way to prove what the actual cost would be were to show what other subcontractors and other roofers in the area do charge. And that's exactly what came into evidence. When the jury saw that evidence, the estimates ranging between $75,000 and $60,000 to actually replace the roof as compared to $190 being claimed, it is not a far logical leap to think the jury saw that evidence and consider that to be a material misrepresentation. So the only thing that we can do is ask, how could we have taken that question away from the jury? And the issues that SFR raises on appeal are, number one, that the intent and the materiality elements could be resolved as a matter of law. But the primary case relied on is the Anchor Insurance versus Triff case. It says the complete opposite of that. In fact, the Triff case says that exaggerating the extent of a loss can be a material misrepresentation. But the elements of intent and materiality should be determined by the jury. And that's exactly what happened in this case. So the Triff case does not give us a reason to take that question away from the jury. The next question they brought up, before I move on, the cases that were referenced by counsel, the Alvarez, the Al-Ed, and the Michigan Millers case, they all dealt with concealment issues, and all of them either went to the jury and were held to be appropriately have gone to the jury, or didn't go to the jury and were reversed because they should have gone to the jury. So all of those also support that this trial court did exactly what it should have and let this question go to the jury. The second argument advanced for pulling this question back from the jury is that there wasn't a reliance issue. And the Stelanovich case is probably the most recent from the second DCA that says an insurance company doesn't need to prove reliance. And I heard counsel say that in the Triff case, there's an element of reliance intertwined with materiality. And if you look at that, what Triff actually said is that if a reasonable insurance company would consider the fact important, that's the element of reliance, or that's how the twist of reliance comes into materiality. Anytime we start talking about a reasonable person or a reasonable entity, again, that's a jury question. And this question did go to the jury. So that's exactly what should have happened. And the final issue that I'd like to touch on is what counsel brought up at the very end for argument is that an assignee should not be subject to the fraud and concealment provision of an insurance policy. And I'd submit that there's absolutely no support for that position in the law at all. And in fact, that argument is contrary to many, many principles in the law. The first, sorry, you're on.
Oh, you might answer this if I didn't cut you off, but the initial brief cites the case that refers to, assignees don't carry the duty, but they carry the conditions.
Right.
Isn't the misrepresentation defense a condition, or do you see it more as an obligation?
It is, Your Honor. I think the case that Your Honor referred to in the initial brief is the Shaw case,
yes,
which references the examination under oath, duty after loss. And that is actually a duty of the insured, whereas what we're talking about here is a condition of the policy. And I think the web roofing case that was brought up is a very good illustration of the distinction between those two. Because web roofing distinguished the EUO duty after loss from the appraisal condition of the policy. And just like appraisal is a condition of the policy, so too is the prohibition on fraud and concealment. Again, that's a condition that should not be wiped away by assignment. And that line of cases aside, if we think about what would happen if we interpret a contract to say that an insured cannot commit fraud, cannot misrepresent facts, and cannot conceal facts. But as soon as that assured assigns his or her rights to another entity, that entity can commit all the fraud, misrepresent all the facts, and conceal everything that they want. That, I'd submit, is the height of absurdity. And we are not allowed to interpret an insurance policy to reach an absurd result. So I think that's another reason that the law will not allow the interpretation that SFR is asserting. The only other argument that I heard come up that I wanted to touch on was the relevance of the Knox agreement, and that's the $1,200 testimony. And that is absolutely relevant in a number of different ways. I think two can pretty much illustrate the point. Number one, it shows what the actual cost to replace a roof would be, as opposed to the $190,000, which is estimated. And that goes to the very heart of Tower Hill's misrepresentation defense. And the other aspect that I think is also relevant is that it is impeachment testimony, it is impeachment evidence to impeach SFR to say that $190,000 is not actually the cost of what this would be. So either way you look at it, the testimony regarding the Knox agreement should have come in, as should all the other testimony about the cost to replace the roof from Mr. Rakos and Mr. Townsend as well. And if we think about what SFR is trying to do by excluding all of the testimony about the cost to replace the roof, other than its own estimate, it's really trying to just conceal everything from the jury that it concealed from Tower Hill. And that's what the entire trial was about. And that's what the jury based its decision on. And for those reasons, this should have gone to the jury. The trial court did the right thing and the jury did the right thing. And we think the matter should be affirmed. So if the court has no other questions, then we will rest on our brief.
Any other questions? Thank you.
Thank you.
here, I think, and I was trying to remember, I think I have it written down wrong. I have it's the policy. All of these conditions are located under the subject conditions, so I find it difficult to piecemeal out one condition. I offered a very rational explanation as to why web roofing makes sense. It's not a ridiculous result to, it doesn't deprive insurance companies from defending against individuals or companies that make claims that are false. There's defenses like unclean hands, there's counterclaims, whatnot. Again, TRIF was a denied claim. I'm just gonna reiterate again, this is the case to draw the line on, at the end, my opponent said, that there was evidence concealed from the jury. Well, that's the same as saying there was no evidence presented to the jury as to, what the cost of the subcontractors estimate was. So, they're bound by their pleading. They didn't prove pleading. And just in general, just a disagreement over price and scope, when there was and there's repeated testimony from the corporate representative, even after receiving the estimate from SFR, we didn't do a estimate, there's no coverage for the claim. They reiterate that time and time again. I think we're missing a false statement. I don't think they met the burden of proof in their affirmative defense. There's lots of ways they could have asked for that, received it, even if they had to take it up to the appellate court and say, this is information that we need. There's a lot of I don't know, but, they didn't take those steps. They didn't offer evidence to substantiate the allegation that the cost to repair this roof was going to be done by the subcontractor. And then, just the sheer refusal and just disregard of the estimate. I mean, that has to count towards materiality. And again, I think if the court looks at some of the cases that do have enough evidence to get to the jury, there's disputed issues of fact, there's proof, every single summary judgment case, Wong Pen, Mesidue, which I was counsel of record in, there was a concession, there was an admission, there were undisputed facts, Wong Pen, or might be getting them confused, but one of them was like, oops, we didn't really have an ALE claim, or oops, we, didn't really have $67,000 worth of art, we, reduced it. So, I mean, this is that case. There's just no concession that there was any false statement made. There's no concession that the estimate was inflated. The claim was denied. The carrier took no response. They didn't even re-inspect the property. They didn't feel the need to, ask for more information. They did such a very minimal claims investigation to begin with. So, they could have, upon receipt of that, investigated it. They could have sat down with the insured. They could have asked SFR to, provide documents. They could have done a lot of other things. So, this doesn't get us to the jury. There's not enough. To the court, to the extent the court disagrees with me, I truly do think that verdict is the manifest weight of the evidence. So the relief we're asking for is either a reverse and a man for just a trial, or for a directed verdict to be entered on the affirmative defense of fraud and concealment, and a new trial on damages. There was no cross appeal on the answers to 1 and 2. But if the court thinks a directed verdict is inappropriate, we'd ask for a new trial just on the issue of the fraud and concealment and damages. So thank you for your time.
Thank you.
All right.
We adjourn. Thank you.